Well, you can't touch it or feel it, and oftentimes you can't even see it. But intellectual property may be among your enterprise's most prized possessions. Comprising an increasingly greater portion of a typical company's assets. In general terms, intellectual property is any product of the human intellect that the law protects from unauthorized use by others. The ownership of intellectual property inherently creates a limited monopoly in the protected property. In other words, no one else or no other entity can steal it or copy it or use it without your permission. Generally, intellectual property is traditionally comprised of 4 categories: patent, copyright, trademark, and trade secrets.
Of course, in this age of instant global communication, understanding what intellectual property is, how to protect it, and how to enhance its value are survival prerequisites for corporate financial executives. In recent years, investors and lenders have become much more critical in their analyses of intellectual property, often when credit lines are extended or during a due diligence process. Their focus? The verification and the valuation of intellectual property ownership. Anthony Gangemi, a partner in Murtha Kalina's business and finance department and the chair of their intellectual property group, explains why enterprises are so interested in their intellectual property assets these days.
Well, the main reason is the majority of the value in most companies nowadays is actually in the intellectual property versus, the tangible property or the hard goods, so to speak. In fact, right now, in a recent study I read in 2015, 80% of S&P 500 companies hold their value in intellectual property. And that's a 70% increase from 1978 rather, when it was only 15%. So, when most of your companies made up with IP assets, it's got to be important to you. So when the value of a company is tied to IP, its book value naturally is tied to the IP. And that flows down to management decisions, as it will at least indirectly impact the stock price.
Tony Gangemi reminds us that while owning intellectual property is vital, organizations have to maintain it and protect it as well.
Just as you'd maintain your brick and mortar, you need to maintain your IP portfolios as well. The strategic reasons for maintaining these: if you're in a market where key players start to have a buildup in their patent portfolios, it's a matter of survival. You're going to have to build up your patent portfolio as well, so that in some cases you might have at least a defensive posture. Otherwise, as time goes by and those patented products make it to the market, you may be closed out of that market and not be able to compete.
According to Gangemi, there are strategic as well as financial reasons for an enterprise to maintain its IP portfolio.
Having your own valuable patent portfolio or IP portfolio will give you a big stick deterrent to actually dissuade other companies from coming after you. If they know you hold IP that might potentially cover some of their activities, they're going to be a little bit more careful and selective when they're determining whether they should go after you or not for patent infringement. In other situations, you're able to use your IP portfolio, or in most cases patent portfolio, sort of as a chip in negotiations. So if you're sued, for instance, for patent infringement, a lot of these cases settle with cross-licensing deals where you basically take a license to use the plaintiff's IP, and then they get a license to use your IP. But of course, you have to have some IP in your basket to be able to enter into such a deal.
If all of our viewers were located in Silicon Valley, Tony Gangemi's counsel would be second nature to them. But he emphasizes that even Main Street businesses own and must protect their intellectual property.
Well, let's keep in mind, intellectual property is more than just patents. It's also trademarks, copyrights, and trade secrets. And so even a low-tech or mom and pop or Main Street business, if you will, they will hold some IP. They might not have a patent, and they might not have any registered intellectual property, but at the very least, the name of their company or the name of their business is going to be a trademark, for example. And then on top of that, most of these businesses will have operating manuals. They might have proprietary software, or other things that might be trade secrets or copyrightable material. And so it's important to even those types of businesses to protect those things, because if somebody was to come in and blatantly, for example, steal their website, or blatantly steal their marketing materials that they invested in, or copy their name, certainly that could be catastrophic if in the short run, even for a lot of these smaller businesses, because a loss of revenue over one quarter in a lot of cases can shut down one of these businesses. So it's actually very, very vital to those companies to make sure that does not happen.
According to Tony Gangemi's practice, it makes sense for enterprises of all sizes to make sure that their IP is both properly registered and protected.
I work with a lot of companies who just ask me the fundamental question: is there any value even in filing for patent protection? It costs so much money, it takes so long to get the patent. Should I even go down that path? And sort of the answer that I give to each one of those, frankly, is different, because it's really based on, what is your business? If you're working in an area where the technology turns over at a very rapid pace, sometimes patent protection is not the right way to go. Sometimes it's better to spend money, on branding or getting the product to the market first. That said, in some of those situations, even where the technology is moving rapidly, sometimes the underlying technology is used as a building block for the next iteration. In those situations, patent protection might be very valuable. So, while there are a lot of good reasons for filing and a lot of good reasons for not filing, at the end of the day, one of the things I do say is that if it is something that you can add to your company as an asset, you can't make that decision later after you've started selling the product. So it is a decision that you should at least address up front as part of your IP management plan. I mean, if you don't go after protection, you may be, as I mentioned, at a major loss in a very short period of time. And so having statutory protection and actually going after federal registration of trademarks and copyrights, it's important because there are some statutory benefits to actually filing that you'll get from that registration. And I'll give you an example with copyrights. If you publish, or if you file for copyright registration within 3 months of your publication, you're actually entitled to some statutory damages, which can be extensive. And I think even more importantly, you're entitled to basically recover attorney's fees. And so those would be plaintiff's attorney's fees in that situation. And that will actually pay for the lawsuit that you're going to have to go after somebody to enforce it and shut somebody down. And that's often a very big stick and a big deterrent, and will stop a case in its tracks when they realize that you have that at your disposal.
Since we've seen an uptick in corporate restructuring and acquisitions, Tony Gangemi is not surprised that the IP portfolio is under increased attention and scrutiny.
In a lot of M&A deals, there's a reason for the deal, right? I mean, a lot of times there's efficiencies that you're trying to seek. A lot of times it might be intellectual property. And then other times maybe it's just the customers of the target company. And so the due diligence process will actually go along the path of what those goals are. If intellectual property is a large reason for actually going after that target, you're going to want to look at that intellectual property, and you're going to make sure, in the case of patents, you're going to look at the patent claims, and you're going to want to see how broad are these claims. What's the scope like, and how does that fit into the portfolio that we currently have? Does that help us, or does it turn out that the patent claims that were granted are actually very narrow? We learn that through the due diligence process by looking at. We get into the weeds on that, frankly. We look at the prosecution history at the patent office, and we see, what will the scope of those claims be construed as if they're ever having to be enforced. And so that informs your decision, and you say, okay, this is either going to be value to us or not, and that will impact, certainly the price of the deal. In other situations, you might only really be wanting to get those customers, and the IP is really not all that important. So you might do an abbreviated due diligence of that underlying IP, and certainly you're still going to acquire it, but at the end of the day, you're really probably more focused in those situations on just seeing that the asset's properly transferred over to your company.
Yes, since we're dealing with financial executives, we end up mentioning the securities law on almost every program. But Tony Gangemi emphasizes that, especially since the enactment of the Sarbanes-Oxley Act, financial executives have been especially concerned about where their IP assets are located, how they are valued, and how they are being protected.
Under Sarbanes-Oxley, you do have reporting requirements, and you need to know the value of your company. And if it's a company where 80% of the value is tied up in intellectual property, then certainly you need to know what you own, where it is. You need to know the value of what it is, and you need to make sure that you have some safeguards in place to protect that valuable property for your business. Failure to do so would be a failure to be in compliance with Sarbanes-Oxley.
Of course, our viewers have locations and deploy IP assets all over the globe. Yes, they have to protect those assets, but according to Tony Gangemi, that means that they also have to be aware of how to protect those assets under different legal systems.
While you can have intellectual property all over the world, and most major companies certainly do, I mean, there are differences in the types of protection that you get. Most countries in this world now have patent systems, and certainly there's ways to protect trademarks and copyright, and trade secrets are what they are. But there are some differences in various places. And I'll give you one example on the patent front. On the patent front, if you disclose something before filing a patent application, you have a 1-year grace period typically where you can file. In most other countries in the world, there is no grace period. So if you have one of your scientists go and present at some conference before you filed, say, a provisional application, at least in the U.S., you would be barred from filing in Europe, for example. Intellectual property is territorial, so that would mean IP that you have in the United States only protects your stuff in the United States. But in a lot of situations, your more important markets are not in the U.S., and so you've gone out and you've actually staked your claim in those countries as well, and so you're going to hold intellectual property all over the world potentially if it's a really important product to you and you have customers all over the world. So in that situation, you do the same things that you do with your United States IP, and that is, know what you own, and then value it, and then have safeguards in place to protect it as well.
As financial executives, our viewers are quite familiar with the concept of taking an inventory, which typically includes how much those assets are worth and how they're being protected. Presumably, that makes just as much sense for intangible assets in the way it does for tangible assets.
So when you're looking at intellectual property, it's vital to keep track of it. And in fact, it's often a situation where when you compare it to tangible property, it can kind of slip through the cracks if you don't keep track of it. For example, when you're filing a patent application, often there's low-level approvals that are required in a company to do that filing. And so you're not having a situation where when you're building a new plant where everybody's engaged in the process and certainly everybody's aware of that property. And so if you're not careful and you don't have a plan in place to keep track of that kind of property, it can happen. It can come down the pike where you actually don't safeguard it properly and then wind up losing the assets. So having a plan in place will ensure that you take care of those valuable assets.
Yes, a company's IP portfolio can serve as valuable collateral for debt. But Tony Gangemi points out that in recent years, companies have monetized the value of their intellectual property in order to create revenue for the enterprise.
In addition to having a system for keeping track of your intellectual property, just so that you don't lose it and that you can maintain it, there are some reasons, also that I would say are more on the offensive side of things, and that is you can use your intellectual property to actually generate revenue for your company. A lot of companies have plans to monetize their IP in a couple different ways. I mean, one, you can go on sort of a licensing program where you look to use intellectual property, that you maybe don't use in your own products anymore, and you look to actually make money from them by licensing those out to smaller competitors, different markets than you're really tied up in. And I'll give you an example there. IBM's famous for that. They actually have an in-house program where after 18 months, their patents are automatically licensed out. And And they do that for a reason. They want to try to drive innovation. They drive revenues with it, but they also drive innovation. And so for a lot of companies, sort of a combination of those reasons pushes them towards trying to monetize. And another thing that you can also use your intellectual property for is actually to finance other projects. And you use it for collateral on credit lines and loans and that sort of thing. And so by driving the value of your IP portfolio as high as possible, that certainly is going to allow you to have more collateral and allow you to secure more funds.
When it comes to doing a financial audit, our viewers are quite comfortable with their role in performing an internal audit. But they also call upon a CPA firm to come in and do an independent audit. Who should do the work on the intellectual property audit? Is it the in-house people? Or do you really need independent people? Or is it both?
Well, for an IP audit, we typically recommend that you hire IP professionals. And so a lot of times those are found in a law firm. Sometimes consulting firms will have them as well. And in some situations, in-house counsel can perform those functions. I mean, larger companies sometimes have extensive in-house counsel or in-house IP counsel, rather. But we still recommend in any event for at least the first audit, if you don't have a system set up, you hire somebody who's done an IP audit in the past. You have them come into the situation, conduct the audit, help you get set up for the future, and then maybe the next couple of audits you could do yourself, and then maybe you have some sort of schedule where you bring them back and you have an outsider do the audit on a regular, say every 3 years. And in any event, what you want to have is a plan. And to have that plan and have an effective plan, you want to work with somebody that's actually developed a plan in the past.
From Tony Gangemi's perspective, the IP audit is actually a key part of an enterprise's intellectual property management plan.
Sure. IP audits are really an inventory of the intellectual property that your company owns. But it really needs to be part of a larger plan, an IP plan, so an IP management plan, rather. And in that plan, you're going to first take the inventory, and you might do some valuation so that you know exactly what the value is of what you own. But you're also going to follow up on that by protecting those assets. And one of the things you do when you're protecting those assets is you look to see what your competitors are doing. So you can actually set up a trademark watch, for example, and so you police your trademarks. Anytime somebody's using something that's close, you'll get a little tickler, and you'll be able to send out a cease and desist letter and try to bring that to a halt. Same thing on the patent front. You're going to police patents, and you're going to see what competitors are gaining new patents in these really important areas for you. And a lot of times, just from looking at what they're doing, you can tell that they may be treading on your rights. And so that's an effective way, actually have a system set up to police these various areas of IP so that you can shut down any unauthorized use. You can also learn a lot about the market and the landscape. You can see who's actually funding research. You can see who's actually spending more money on R&D on the private side. You can learn what universities have top scientists in a particular field. And you can see as the landscape changes and new players enter, you can see those players and learn their names and figure out who they are. And so there's a lot of things you can learn that can sort of inform your business strategy and not just give you a reason to sort of go after somebody in a lawsuit, but actually help you be more competitive.
What about the situation where a company finds out that someone else is infringing on their patent? On one hand, they are working on something else that has a super high priority. But on the other hand, they do want to bring an action to protect their property before the deadline.
Whether to enter into litigation to enforce your patent rights is a complicated question, certainly. It depends on the players involved, the size of the companies involved, their willingness to litigate in the past, all those sort of things. The strength of the IP that you might go to court on will all factor into it. And so a question I'll often get asked is, how does that impact my case? Can I wait? Do I need to do it right now? And we walk through it. And one of the things is we look at how much patent term's left. And basically, under the patent law, it's actually in the statute and under recent case law, even at the Supreme Court level, you have a 6-year look back for damages. So if your patent's still in force, you can go back 6 years and capture any of those damages.
As Tony Gangemi indicated, the law does provide for a 6-year deadline in bringing a patent infringement action. But we have aired other segments on this program where a defense attorney mentions laches, when someone has waited unreasonably long to bring their claim against a defendant. Is that a possible defense in a patent case?
Well, very recently, in March of 2017, the U.S. Supreme Court actually reversed the Court of Appeals for the Federal Circuit, and they came out and they said, no, as long as you're within that 6-year look-back window, there are no laches arguments that can be made.
Yes, Tony Gangemi indicated that the U.S. Supreme Court overruled a decision by the U.S. Court of Appeals for the Federal Circuit. And yet, that tribunal, the Federal Circuit Appeals Court, specializes in patent and trademark actions.
Court of Appeals for the Federal Circuit is actually the specialty court that takes on all patent cases that are appealed from the district court level. So they're experts in that area. Well, in that decision, it was actually a 6-5 decision to continue to allow laches in patent cases. So as you could tell from that, they were very divided, very split. So it wasn't a big surprise when the Supreme Court decided to go the other way with this.
Since he already mentioned that businesses own other types of intellectual property, Tony Gangemi commented on what would have happened if this case involved a copyright.
No, actually, in copyright law as well, they have a similar setup, and that is in the copyright law, there's sort of a 3-year statute of limitations or 3-year look-back period. And so what happened actually in the SCA hygiene is the court was really trying to bring some uniformity there, or some consistency, I should say. And the case with copyright law was a case Petrella v. MGM, and in that case they actually said, that 3-year look-back applies with copyrights. And so here it makes sense.
Obviously, intellectual property is of current interest to the Supreme Court. And there is a current dispute that the High Court will decide later this year, where a printer company wants to forbid others from refilling its toner cartridges. Tony Gangemi tells us if it's really possible that a patent owner, like Lexmark, can forbid what their customers can do with their products after those products are purchased.
It's been longstanding law that a patent owner can actually make conditional sales of its patented products. And so, under the patent law, you have the right to exclude others from making, using, selling, offering for sale, or importing your patented products. However, you can also have a sale that's conditional, which would be you're granting less than all those rights. And in this situation, in the Lexmark case, Lexmark actually made the sale conditioned upon you're not allowed to resell those printer cartridges. And here, the party came in and they purchased these used cartridges, and then they did just that. They refilled them and resold them. So they breached the condition upon which they were sold. And under the law, if there's a breach of that condition, you actually can go after folks for patent infringement. And when I say folks, I mean not just the party that purchased the cartridges, but downstream as well. So you're looking at customers, and users alike in that situation. And that's what really has gotten people pretty upset over this particular case. The Supreme Court heard oral arguments in this case very recently in March of 2017. And really what it comes down to is whether they're going to fundamentally change what's referred to as the patent exhaustion doctrine. And under that doctrine, if an authorized sale of a patented article is made, once that sale is made, everything downstream, the patent rights are exhausted. So no one can sue for patent infringement. So, for example, in a resale case, if all of the rights were made in an authorized sale or were conveyed in an authorized sale of the patented article, anybody downstream would be free from any possible claims of patent infringement, whether they resold it, used it, whatever it may be. And that's where this case is interesting, because we did have a conditional sale. And so they're trying to have a situation here where they want some definition or some certainty rather for those downstream users. Is it exhausted, or can you actually have a conditional sale, or is any sale an exhaustion? And so that's the question that really needs to be answered here.
When I used to go to the movies, the thieves would drive up to the company with a truck and would have to remove an entire safe from a building to get the valuables. In today's films, the bad guys just walk in the front door with a thumb drive in his pocket.
Well, as we noted before, a lot of these companies, the majority of the value of the company is in an intellectual property or an intellectual asset, and so a lot of that information is something that you can simply obtain from a computer hard drive with a thumb drive. What makes matters worse is a lot of these situations, this egregious sort of theft of your property is done by somebody close to you, or maybe it's an employee in your own company. And so they walk right in the front door. They maybe use a thumb drive that was provided to them by the company, and they're on their way out with your valuable information and taking it to, say, the next employer. And it's a huge problem that we have, and one that we should be concerned with.
That makes sense. But does that mean there's a difference between, on the one hand, protecting a company's data and information, and on the other hand, protecting its intellectual property?
You think about trade secrets, for example, that really, a lot of times it's customer lists, it's data, it's proprietary software. It's that type of information that's vital to most organizations. And you think about a law firm, for example, and we have, I don't know how many gigabytes or terabytes or whatever the number would be of data stored on various drives. That's certainly proprietary trade secret information in some situations. Or when you think about a lawsuit, it's the strategy for a case would certainly be intellectual property to the company that's a party in that case. And so, from a law firm to a bricks and mortar business, that type of information is certainly their intellectual property as at least a trade secret. And in some cases, it's actually information that's going to be converted into a more identifiable IP regime like a patent, and maybe it just hasn't been filed on at that point. So there's not a lot of difference. Certainly, a lot of the same safeguards need to be used to protect that digital data. Even though my focus today has been on intellectual property, one of the things that I want to touch on is that all companies, or most companies today, have employee manuals, and you've got the policies in there that cover what devices folks can bring to work, what things they need to keep confidential. Maybe they even have to sign a confidentiality agreement as part of that manual. And the other thing you have in those manuals, often you'll have conditions that talk about any intellectual property that's created during their job has to be assigned over to the company. I mean, things like this are things that you need to revisit on a regular basis. Case law changes, routinely, regularly, and a lot of these cases can impact some of these policies that you have in place.
As Tony Gangemi notes, trade secrets are, in many ways, different than other types of intellectual property, such as patents and copyrights.
Trade secrets are sort of a unique area of intellectual property because you don't, on one hand, you don't really do anything affirmative like go to the patent office and file an application or register the secret somewhere, at the copyright office or the trademark office. But on the other hand, there are things that you do need to do, and that is you need to safeguard those trade secrets. You need to do things to preserve the trade secrets because once it's no longer a secret, it's no longer a trade secret.
I asked Tony Gangemi about a hypothetical situation where a company has very distinctive-looking delivery trucks that bring its products to its customers. If a competitor wanted to, they could just follow the company's delivery vans and see who their customers are. So, would you classify their customer list as a trade secret or as something that's generally known?
I would not say that. I think there's a lot more to a customer list than just the identification of that particular customer. And certainly, a bad actor, or maybe that's even bad action, but somebody that wants to go that route and follow trucks around and record the name of companies and addresses, they can do that, and there's no way you're going to be able to stop them. But what you're going to want to protect are actually the names of the individuals that are at these companies, because what it really comes down to is relationships, and you're going to want to protect the names. You're going to want to protect the particular deals that you have with these companies. How much money are you paying them? How are they being compensated? That sort of thing. And these are all things that are going to give you a competitive advantage. And that's really the trade secret that you're protecting, and not just the name of the company.
It's not just the judicial branch that's making law in the area of intellectual property. Exactly 1 year ago, Congress enacted the Defend Trade Secrets Act. As a result, companies can now bring an action for misappropriation of trade secrets in a federal court rather than in a state court.
The nice thing about the Defend Trade Secrets Act is that it actually rounds out federal protection for all the areas of IP. So, you have patent, trademark, copyrights, and now you have trade secret protection at the federal level. And what it allows a company to do is, for example, if you have a situation where you have trade secret violations in more than one state, you can now bring a single action that has all those claims in it. Another thing it can allow you to do is avoid all the complexities of different states. Every state has their own law. There's different, hoops you basically have to jump through in those various states. For now, I think a lot of these actions are being filed in both places, but at some point, when there's a comfort level with this federal regime, you're going to be able to just go the federal route and have some certainty, as to how to proceed in those particular cases.
No one wants to find out that their trade secrets have been misappropriated. In some cases, it's an inadvertent loss. You're a victim of phishing. But in other cases, it's intentional. An employee is unhappy and/or leaving. Under the new law, your remedy for the loss of trade secrets may differ, depending on whether the misappropriation was intentional or not.
There are differences, depending on basically how egregious the behavior is. If it's something that's inadvertent, you're not going to be able to go after somebody for nearly as much. But if it was particularly bad behavior, there are some things at your disposal in the Federal Act, such as you basically go after attorney's fees, which is a big deal. I mean, these cases are expensive. Another thing you can do is go after sort of enhanced damages. So not just get compensated for the damages that occurred, but actually punish somebody with some enhanced damages if their behavior is particularly bad. The other thing you can go after is actually seizure of property. So in some situations, somebody that's misappropriated trade secrets, you can go after that party and actually seize some of their assets to prevent further misappropriation. There are a bunch of hoops you have to jump through, certainly, in that situation, but it is nice that it'll be certain as to what you're going to do with one actual regime, regardless of what state you're going into. Whereas even if other states do offer some of those protections, there are going to be different requirements in each different state. So this allows you to learn the law, the federal law, and then be able to go into any jurisdiction.
Mirtha Kalina's Anthony Gangemi concludes with his advice to those business executives who are concerned about the cost of registering, protecting, and maintaining their intellectual property.
Well, the first thing I'd say is, have an IP management plan, and that starts with, conducting regular periodic audits, IP audits, where you, identify what IP you currently have, identify what new IP that you've actually, in the recent period have generated or acquired, and then take steps to actually protect that IP. So, set up watch services, identify when folks are actually treading on your rights, and then take steps to actually enforce those rights. So, whenever I speak to financial executives or companies in general, I'm pretty quick to remind them to take a look at the policies you have in place, and certainly my focus is intellectual property. So I say take a look at the IP management policies that you have in place. Make sure you've updated them, with respect to any changes to the law or, and oftentimes more importantly, changes to your company. Make sure you're covering your company. Make sure you're actually protecting these valuable assets for your company, and if you're an executive at a company, make sure you're complying, with your duties under Sarbanes-Oxley as well. Well, I'd say have a concrete plan. I mean, when you think about intellectual property, think about the other assets that are valuable to your company. think about, for example, an automotive product or a delivery truck. You're going to change the oil on that thing every 3,000 miles. And if you fail to do that, you might learn when you're out on the highway and there's a puff of smoke and the engine blows up on you that, oh boy, I should not have forgotten to change the oil. Well, similar to those important assets, think about intellectual property that way. You need to maintain it. It's important to your company, and in a lot of instances, as I'm sure everybody knows, IP is a large part of the value of a company, and therefore you need to preserve it and take care of it if you want to maintain that value for your company.